Hello everyone, welcome to Shorthand Battle. I am Divya and I am going to dictate you a legal passage of 500 words at the speed of 90 words per minute. So get ready for the dictation. 3, 2, 1 and go. The High Court has overlooked the distinction between post and vacancy if the requisite posts were already exhausted by direct recruits against the earmarked quota for direct recruitment. Merely because some vacancies occur, it would not be open to the aspiring candidates against the direct recruit quota to challenge the selection process commenced from the post of judicial officers by promotion through limited competitive examination. The cadre strength is always measured by the number of posts comprising the cadre. The right to be considered for appointment can only be claimed in respect of a post in the given cadre. The percentage of quota has to be worked out in relation to number of posts which form the cadre and has no relevance to the vacancy that would occur. This aspect has been glossed over by the High Court in the impugned judgment. Suffice it to observe that as no post for direct recruits existed as on 30th April 2008, the challenge to the selection process to fill up the vacancy by promotion through limited competitive examination at the instance of aspiring candidates by direct recruitment cannot be countenanced. The writ petition filed by such aspiring candidates therefore ought to have been dismissed by the High Court. Having said this, it must follow that the selection process of 2008, which has been completed pursuant to the liberty given by this court by way of interim order, is proper and has become final. On this finding, the challenge in the companion writ petitions to the selection process commenced for the year 2010 does not merit interference, in that the vacancy position as on the date of the notification, that is 4th November 2010, for commencing selection process in 2010 were only up to 8 vacancies for appointment by direct recruitment from the bar. None of the writ petitioners before this court claim to be within the first 8 merit list candidates. The petitioners were placed at serial number 9 onwards. The first 8 candidates having been appointed, the selection process for 2010 would get exhausted and considered as complete. Merely because the names of the writ petitioners appear in the selection list, they do not acquire any indefeasible right in getting appointment. The vacancies have to be filled up in conformity with the extant regulations. The selection process in which the writ petitioners participated was commenced on the basis of the said notification for 8 notified vacancies, and appointments have been made from the meritorious candidates. That selection process must be treated as having come to an end. The fact that the notifications for subsequent selection process issued by the High Court notifying different or higher number of posts for direct recruitment can be no avail to the selection process of 2010. That changed position is ascribable to subsequent period on the basis of availability of posts for direct recruits. Similarly, the fact that one candidate amongst the appointed 8 candidates after due selection subsequently resigned, no right can accrue to the writ petitioners on completion of the selection process of 2010. Stop.